Hollywood's brightest stars have long commanded public fascination, but when legal battles erupt behind the scenes, the glare of the spotlight often reveals conflicts far more serious than celebrity feuds. In late April 2025, Blake Lively, a leading actress renowned for her work in film and her emerging entrepreneurial ventures, found herself at the center of a high-profile lawsuit against director Justin Baldoni. What began as a civil rights complaint alleging sexual harassment and retaliation on a film set has rapidly evolved into a broader confrontation that now entangles global music icon Taylor Swift, raising questions about the intersection of fame, legal strategy, and public perception. The dispute originated in December 2024 when Blake Lively filed an 80-page civil rights complaint with the California Civil Rights Department. The document detailed multiple instances of alleged misconduct by Justin Baldoni during the production of the 2024 feature. It ends with claims that included body shaming and defamation designed to undermine Lively's reputation. Swift public statements by Lively underscored her intention to pull back the curtain on these sinister, retaliatory tactics and to safeguard others who might speak out against similar behavior. Shortly thereafter, Lively escalated her action by lodging a federal lawsuit accusing Baldoni, his production company, Wayfarer Studios, and various personnel associates of orchestrating a campaign to damage her professional standing. Not content to wait, Baldoni countered in quick succession. In late December, he sued the New York Times for $250 million, alleging defamation over a December 21 exposé titled, "A We Can Bury Anyone." Inside a Hollywood smear machine, the newspaper has since denied the allegations. On January 16, 2025, Baldoni advanced his legal offensive further by filing a $400 million defamation and extortion suit against Lively, her husband Ryan Reynolds. He accused the trio of fabricating false accusations of sexual harassment and claimed financial damages resulting from the supposed scheme. Amid this tit-for-tat legal exchange, an unexpected turn emerged in early May 2025. On Friday, May 9, 2025, reports surfaced that Taylor Swift had been subpoenaed as a witness in Baldoni's lawsuit. The notice, issued by Baldoni's attorney, Brian Friedman, sought Swift's personal testimony and any relevant communications. This development arrived only hours before Blake Lively shared promotional content for her haircare brand, Glamour's stories, prompting observers to question the timing and optics of blending commerce and courtroom drama. Taylor Swift's legal team reacted swiftly and forcefully. A representative issued a detailed statement to dailymail.com, emphasizing that Swift had no substantive involvement in the creative process. Of it ends with us. A Taylor Swift never set foot on the set of this movie, the statement affirmed, adding that she did not score the film, see an edit, or make any notes on the production. It noted that Swift first viewed the finished movie only weeks after its public release, having spent 2023 and 2024 touring globally. The rep clarified that Swift's sole connection was licensing My Tears Ricochet, a track from her 2020 folklore album, a distinction shared by 19 other artists whose music appears in the film. Swift's camp concluded that the subpoena is designed to use Taylor Swift's name to draw public interest by creating tabloid clickbait, instead of focusing on the facts of the case. Blake Lively's own representatives echoed those concerns, condemning the subpoena and the notion of selling tickets to Madison Square Garden for her deposition. In a statement carried by People, Lively's team accused Baldoni's counsel of turning a case of sexual harassment and retaliation into entertainment for the tabloids, and of publicly bullying and shaming women's rights advocates. They highlighted a current motion to overturn a California victims' rights law, decrying it as an unconstitutional assault on legal protections. On the legal strategy front, Lively's lead counsel, Mike Gottlieb, confirmed that his client is prepared to testify under oath. Addressing speculation about which witnesses might be called, Gottlieb questioned the relevance of high-profile figures like Swift and Hugh Jackman. This is a case about what happened to Blake Lively when she raised claims of sexual harassment on the set. He told People. It's not a case about how songs were chosen for the movie. You can't just go around subpoenaing people because they're famous, and you think it will generate headlines. The federal courts don't tolerate that kind of behavior. In turn, Brian Friedman dismissed these objections as a distraction from the underlying evidence. Although obviously uncomfortable for the lively parties, the truth is not a distraction, Friedman asserted. He pointed to unedited receipts, documents, and real-life footage that he says substantiate Baldoni's positions. Friedman further charged that Lively brought her high-profile friends into this situation without concern for their own personal or public backlash, invoking Lively's own reference to Swift and Reynolds as her dragons in text messages. He suggested that Disney might bear some responsibility if shareholder revenues were used in supporting Reynolds' alleged personal grudge. The litigation has already had tangible professional consequences for Baldoni. Soccer Day. In early 2025, Wayfarer Foundation announced its impending closure, and Baldoni was dropped from major talent agency WME, though the agency has denied that Lively or Reynolds influenced the decision. Both parties have agreed to seek consolidation of the federal cases into a unified proceeding, setting the stage for an intensive discovery period and a likely trial later this year. Looking ahead, the courtroom may become a venue not only for resolving individual grievances, but also for testing the robustness of harassment and retaliation laws in California and beyond. Should Blake Lively take the stand alongside potential testimony from Ryan Reynolds, who remains a named defendant in Baldoni's countersuit, the proceedings could further illuminate the challenges that celebrities face when personal disputes intersect with public platforms. Meanwhile, Taylor Swift's refusal to acquiesce to what her team calls a tabloid clickbait strategy may deter similar attempts to leverage star power in unrelated legal battles. As the case progresses, legal observers will closely monitor motions to quash subpoenas, arguments over relevance, and the admissibility of text messages and other electronic communications. And the outcome could establish precedents regarding the scope of witness subpoenas, the protection of artistic collaborators, and the limits of publicity in civil litigation. For now, the world watches as one of Hollywood's most prominent couples navigates a legal landscape where the stakes include personal reputations, corporate accountability, and the evolving standards for addressing misconduct in the entertainment industry.